record. All right, welcome everybody to our wonderful DFW Muslim Bar Association CLE presentation. As we've done in parts of this year, we're running through a variety of different topics, relying on the expertise our wonderful members have, which they can showcase and talk in a very intelligent manner on these specific topics. It's great brand awareness for them, and it's a great way for us as Muslim lawyers to learn about each other's practices and how we can kind of interconnect with one another more often and feel confident in, okay, this is someone that I know, this is someone that I can trust and pass our clients along to them. And inshallah, that'll bear great fruit for the rest of the community here in Dallas and the Ummah at large. So inshallah, that's kind of the mission. We've hit a couple of wonderful topics previously with the Corporate Transparency Act. Inshallah, we'll also have one on joint ventures coming up soon, as well as one on franchise law. So we're going to try to diversify this quite a bit. Part of the DFW Muslim Bar Association, as a lot of you that are attending here know, we've got wonderful programming that happens throughout the year. We have programming coming up that you can find on our website when you log on to dfwmuslimbar.com. We have a kind of like a coffee and connection coming up this weekend. So please look on the site for additional information. It's about voter engagement and voter discussion with another organization that's relaunching itself in the community. And it would be great to see so many of you all at that one. Without a further ado, let me introduce to you the two wonderful panelists that we have for you today. Obviously, my name is Fawaz Baum, and I'm the president of this wonderful organization, but I am outdone by my friend and colleague, Fawaz Maroof, who is a graduate of SMU Dedman School of Law. He has experience in preparing title opinions for real estate, including determining surface and mineral interests, and determining how to apply Texas intestacy laws, some of which we might get into today, based on affidavits of heirships and conveyances from trusts to individuals based on the terms of the trust. This experience allows Fawaz to share to the Muslim community on the importance of adhering to their Islamic duty in a Texas compliant estate plan. Also, not to be outdone is the wonderful Umi Lawan. She is dedicated to helping families secure their futures through strategic estate planning, focusing on family protection, wealth preservation, and value-based planning. She guides clients through complex legal and financial decisions to create personalized plans that protect loved ones and honor family goals. She is a graduate of SMU Dedman School of Law, and she made history as one of the first two foreign law students to pass the Texas bar exam on the first attempt, not an easy feat. She gained experience as a judicial intern for Judge Craig Smith and as an associate at D. Hay and Ellison LLP, representing major national and global corporations. She is absolutely passionate about trust and estate law. She combines her legal expertise with a personal commitment to educating her community about the importance of proactive planning through her law firm, Harmony Legal Group. Above all, she treasures her role as the proud mother of Nina, Jordan, and Leanne. So with all of that, welcome to our panelists, and I'm going to turn it over to them to take us away. Thank you, guys.
Thank you, Fawaz. All right. Fawaz Maroof is actually going to start us off. Thank you so much for that kind introduction, and I really appreciate you having us here, and I'm definitely excited for this. Fawaz, did you want to say anything and dive in?
I do appreciate that introduction, but yeah, we're ready to get started.
Awesome. All right.
Okay, so we are going to talk about, of course, number one, Texas compliant estate plans first and foremost, but also there is a significant duty to prepare for beneficiaries to receive assets based on the Quran. And the Quran, we referenced a few places where the Quran specifies shares. It says if you own anything at the time of your death, these are the people that have a rightful share to it. With that said, that makes it a religious duty upon you to distribute your assets in a specific manner based on the Quran. And also emphasize in authentic hadith, it does say it is not permissible for any Muslim who has something to will to stay for 2 nights without having his last will and testament written and kept ready with him. So according to that, there is definitely a religious duty to do that. So that is why it's important to know how to adhere to that and adhere to Texas law, because the significance of not having an estate plan or not having a will with specific beneficiaries according to the Quran can leave it based on Texas law. So the next slide will dive into a little bit about what happens if you don't have any estate plan in general. So if you don't have an estate plan or don't have designated beneficiary, this is called intestacy. Intestacy occurs when a person dies without a valid will, meaning they died intestate. If they died with a will, they referred to as dying testate. So if they're intestate, meaning they have no will, there's no trust or no beneficiary designations, Texas intestacy laws come into place. Similar to the Quran that has specific shares for certain heirs, Texas law and Texas intestacy law has specific shares for certain heirs as well if you don't have a will, a trust, or a beneficiary designation. So automatically, if you don't have anything in place, you're automatically not distributing according to the Quran. So that is why it's important to have an estate plan, and it's important to understand how to distribute it and who's entitled to it. And that'll lead us to our next slide.
My apologies, Fawaz. I think I clicked on that slide too fast, but I'll go ahead and explain estate plan. And Fawaz mentioned having an estate plan in order to avoid intestacy laws in Texas, because obviously they conflict with Islamic laws of inheritance. And I want to take a minute and explain what exactly estate planning is, because I feel like it is a term that scares a lot of people and is just too legalese. And so if you want to explain it to your clients in a way that maybe doesn't scare them so much, I usually explain it as a comprehensive proactive plan that you're making about what happens to your assets and your loved ones and your body when you become incapacitated and when you pass away. Right. So incapacity essentially can be that you don't have the cognitive mind to make a decision yourself, or you are too sick to even communicate. And so in either one of these situations, if you don't have a plan in place, like he mentioned, the state of law has a plan in place, which essentially requires you going to court, or your loved ones actually going to court and filing for a probate process, which is called guardianship if you're still alive and you're incapacitated, and it's called probate if you have passed away. And then based on those laws of intestacy, that is how essentially the judge is going to decide how your assets will be distributed. The judge is going to decide ultimately who's in charge of financial affairs and healthcare decisions, and appointing legal guardians that will be in charge of those things. And a lot of times, especially when it comes to distribution of assets, we've already talked about this, is actually very different from the requirements in the Quran. Like a perfect example is given a son or male heir twice the share of a female heir. That's one of the places you see conflict a lot. So just real quick, I want to talk about why the CLE is important. We obviously know that there's a growing Muslim population in Texas and all over the US, honestly. And so this makes it very important that when we create an estate plan, that in addition to complying with the state law, that it actually also follows Islamic law of inheritance. And that is the beauty of estate planning, in my opinion, because the whole idea of it is you are making your own proactive plan. You are deciding how distributions should be made, how your affairs should be handled. And so you're essentially taking control of that and making sure that you are complying with the Islamic laws of inheritance through proper estate planning. Because ignoring those religious mandates can lead to an invalid will, right? Or contest. We see a lot of people create the will and it's almost like irrelevant because their loved ones end up fighting over what they leave behind, and then it ends up not complying with the laws of Islamic laws of inheritance, because then the judge is probably going to have to make decisions based on laws, intestacy laws in Texas. And then, of course, as a counselor and as a professional, you want to make sure that you're properly advising your clients around the importance of this. If you have a Muslim client in front of you, helping them understand that as a Muslim, this is what is required of you, which can be, again, very different than what most people want to do. So really, you want to avoid client dissatisfaction as well. Nobody wants to get a complaint with the State Bar of Texas, right? And the pitfalls that come along with that. Um, yeah, so let's go ahead and talk about I think. Oh, that's right. I'm continuing. I was wondering if you were gonna take this one for us, but I realized that it's continuation from the other one. Okay. And then the other few things that we want to cover in this is reviewing Texas wills, obviously. What are the requirements of creating one? And then we're also gonna look at how to draft a will, how it can comply with the Islamic laws of inheritance and the trust as well. And so those are the things we're gonna be covering today, and hopefully this will be helpful for you all.
Hey,
Back
thank
to
you,
you.
Amy.
Mhm.
Yeah, so I'm going to go ahead and talk about wills, and then Ami's going to carry on with trust. So, talking about wills, of course, first and foremost, you want to make sure you have it's all according to Texas law. It's a valid will, so that's what we're going to talk about. There are two main types of wills. It's number one is a attested or typewritten will. It must be attested by at least two credible witnesses. We'll talk about that a little more in the next slide, but they must be at least 14, and they all must sign in the presence of the testator. Testator and the witnesses must all be there together during the signing ceremony. With that, what is a disinterested witness, which needs to sign this? It's someone that generally does not gain any benefit. So here, if there's a witness that is being gifted something from the will, the gift may be void. So it's best to get witnesses that get no benefit from the will itself or from the inheritance. That's the first type of will. The second is a holographic or handwritten will. If it is valid if it's completely in the testator's handwriting and signed by them. This does not require witnesses. A holographic will does not, but the handwriting itself may need to be proved in probate court for its validity. And then next slide, I'll talk a little bit more in detail about specific will requirements to make them valid. Okay. So in Texas, number one, will in Texas must be made with someone with legal capacity. Legal capacity is defined as someone 18 years or older, lawfully married or in the armed forces, and they must be of sound mind, meaning the testator, the person that's signing the will, it's their will. Uh, they understand what they're making. They're making a will, and they understand that they're transferring it to specific people. They just have to have some. They have to have understanding of what they're doing. Number two is it does need to be in writing. Number three, it needs to be signed by the testator or another person on their behalf in their presence at their direction, but generally signed by the testator is one of the requirements. It does need to be witnessed by two credible witnesses, as we talked about, unless it is a holographic will, meaning it is all handwritten. We already talked about the witnesses. They must be 14 years or older. They must sign with the testator, and they should not be interested witnesses, meaning that they should not benefit from the will or get any gift because the gift may be void. And then, of course, testamentary intent. The document must be executed with the intent to dispose of property at death. Now, those are the requirements of it. Now, at the bottom, you'll see self-proving affidavit. This is not a requirement. It's highly recommended. It's just at the end of the will. It's a notarized affidavit at the end of the will, basically attesting that the witnesses signed it. And then that the benefit of that is it avoids the need for witness testimony at probate court in the future. So having a self-proof affidavit attached to the will, the witnesses could be strangers because they never need to attest in probate court. Otherwise, they may need to witness in probate court or appear in probate court. That'll lead us to the next slide, a little bit about testamentary capacity. Again, they must be 18 years old or legally married or in the military and they have to be of sound mind. So the analysis is this: they understand the nature of making a will, they know one's property, they recognize the natural heirs, and they can make coherent decisions about asset distribution. The reason we want to focus more on this, a lot of times, the children will come and say, "Hey, my mom needs a will or an estate plan," and you need to really determine if they have the right capacity, because sometimes they don't, and then the children realize, "Oh no, we need to do something." So it is on you. Just make sure that they are of sound mind generally. And so we talked about what makes a valid will. Now, the way Islamic distribution works is this. Number one, off the top of the assets, the debts are paid, similar to a traditional will or otherwise. The debts of the estate are paid first. Number two, after the debts are paid and before the main distribution, there's, I will say, yeah, a discretionary bequest. So this is optional. This isn't a hadith, and I'll just read it out. Or sorry, I'm not going to read it out, but it basically allows a gift to someone or a bequest that is no more than 1/3 of the estate after the debts are paid. So after the debts are paid, up to 1/3, this is again optional, can be distributed to non-heirs or charities or a friend or adopted child or anyone that would not otherwise inherit according to the Islamic distribution. Again, this is an optional share. So after the debts are paid, after the wasiyah, if there is a wasiyah, then whatever's remaining is distributed according to the Quran, the fixed shares. And that's the part, it's very important to tell, all of you and for you to tell your clients, you're not an Islamic scholar. You follow a objective analysis, but if they have a scholar that says one way or another, you're not a scholar. You're just trying to put their wishes based on the Islamic distribution into an estate plan that's compliant according to Texas law. So the distribution portion, what I would say, and Ami, feel free to chime in, just try to make it objective. For me, and there's Islamic Society of North America, they have an inheritance schedule on there, and and I researched it a little bit. Dr. Munzar Kaf, I'm not sure if I'm pronouncing his name right. He's a religious scholar in Islamic economics and inheritance law, and he helped develop and define it. And it shows who should get what based on separate specific situations. So while you can attach a schedule, you have to be careful about the definitions when it says son and you define it differently in the will or whatnot. Just me personally, I like to specify who it is. Like if I know the wife gets 1/8, I'll write that and I'll say in the event wife passes away, the share before the testator, this share is added to the children. So it's good to understand it and put it in a clear manner, but you could put a schedule, just make sure the definitions align. So basically just have some sort of objective way, because you are not a scholar in this, but have a objective way, consult, you can confirm with different schedules that you found to be relevant or approved by your imam or whatnot, and make sure there's no differences and let your client know this is how I'm preparing it. But If you have anything to add to that.
Yeah, I mean, I agree with you 100%. I always tell my clients I'm not a scholar. I'm an estate planning attorney who complies with Islamic law of inheritance. Ultimately, if the client is very confused about how to go, which way to go, whether they want to give that 1/3 to someone and they're just really confused about all of it. I tell them these are the basic principles, and if you want to dive deeper into understanding what is truly allowed of you and what is not, I recommend they talk to a scholar and just kind of get some clarity and then come back to me, and then we can make sure that their wishes are ultimately reflected in their plan, in their will or trust, whichever one they choose to do.
And thank you. Yeah, and the last point is the burial and funeral rites. There's a specific manner that Muslims do burial and funeral rites. So you do want to put that on there. And what I do on top of that is I nominate someone for the burial and funeral rites, generally the same person as the executor, whoever that is, to handle these affairs. Because I've seen it firsthand where the funeral home says, hey, we can't talk to them about it because unless you have something. And when the will or you have a document regarding the funeral rights, this person has full discretion on it. They'll allow them to make those decisions if they want an Islamic burial or not. So yeah, that's important to add in there. And that's really all I had on this section.
Perfect. Yeah, I know we'll dive deeper into burial as well at the later part of the presentation. Awesome. Thank you, Fawaz. Let's talk about trust for a minute. So a revocable living trust is another post-death planning tool that you can use instead of a will. That's usually how I explain it to my clients because the revocable living trust essentially is supposed to replace the will. And when it does replace the will, what it does is it basically avoids the probate process altogether because a will has to be filed with the probate court of the county where a person passes away, right? And then the probate court has to approve it. So then you're looking at risk of the judge not liking the fact that you're choosing Islamic law of inheritance in the first place, and or just issues with legality and some of the things that may make the will to become invalid. Now, there are some requirements of a trust, obviously, like it must be created by someone with legal capacity, obviously, and it must be created with the intent of actually creating that trust. And it has to be for a lawful purpose, right? There are different types of trust. We're talking about revocable living trust, and the purpose of that is to avoid probate and keep your affairs private. And you must have a trustee and a beneficiary. And this is a good time to actually explain what a trust is. Since I'm talking to lawyers here, let me give you the technical definition of it. It's a complex agreement that you're making between a grantor and a trustee to hold assets for the benefit of the beneficiaries, right? And so as you can see, there has to be those three different parties in a trust, the grantor, the trustee, and the beneficiary. It must generally be in writing. You can't really have it any other way. And then it's usually revocable. Unless it is made irrevocable, which is a completely different type of trust that we're not talking about today, because that is mostly for asset protection. We're mostly talking about a revocable living trust today that's used for estate planning, that is mainly keeping your affairs out of probate and keeping it private. And so that's what a revocable living trust is. And so some of the advantages of a revocable living trust is that it avoids probate, as I've mentioned, and it continues and serves you even during your incapacity. It doesn't kind of wait until you pass away. Even when you're incapacitated, your trustee can step in and basically conduct your affairs just like in accordance with your goals and objectives and Islamic law of inheritance if there's a need for it. It is governed by Texas Property Code if you want to go into that law and dive deeper into the details and requirements of it. But one of the things that I want to mention is that similar to the will, the distribution side of it is kind of the same here too. So a third of your estate can be discretionary wasiya, right? And then the two-third can be fixed shares to Islamic heirs per the Islamic law of inheritance. So that's where all the schedule comes in, where you list out the different family members that are still alive. and the shares that they're supposed to get, and the trustee is required to distribute those assets in accordance with that schedule and the requirements. The only important thing to keep in mind is with the trust, those assets that the person making the trust owns, they have to be moved into the trust, which is what's called funding the trust. And I think I'm going to talk about that on the next slide. But an example of a clause you can add in there is, upon my death, the trustee shall distribute the trust assets in accordance with the rules of Islamic inheritance law. I personally love this because it is sort of like a catch-all clause in case those distributions change and you're not able to update your trust before you pass away. What happens? Then somebody has to recalculate the whole thing, right? We don't want to have a trust end up in the court again, because the whole point of it is to avoid the court. So then having this catch-all clause that says, this is what I want my trustee to do, no matter what happens with those distributions I have in place, right? I think that's one of the most important clauses you can add in the trust. And then, so one thing that's important, and I guess I'll mention about the funding of the trust. I thought that was the next slide. But when you fund the trust, you have to move your home into the trust, your bank account, your retirement account, your life insurance. Now, there are nuances to that, right? Every asset moves into the trust in its own way. And I can definitely answer questions about that. But the home is one of the biggest assets for a lot of people. And so many people have questions about what happens when you move that home into the trust. Well, there's different laws that allows you to move your home into the trust. And I'll talk a little bit about one of the most important laws on the next slide for sure. But I want to talk about homestead exemption. This is something I see come up in our office every single week. When we move a home into a trust, usually our clients would get a form and a letter in the mail from the county, and it asks them to reapply for homestead exemption. And this is really important for a lot of people, not just the tax savings, but the protection that it gives a surviving spouse and heirs to remain in the house and not be kicked out by any other person that may feel like they're entitled to that property, or they actually are entitled to that property. So that protection it gives the spouse, right? It comes through the homestead exemption. And of course, community property laws. So when you get that form in the mail, what we ask our clients to do is just to fill out the form, and we have a section of the trust that we specifically designate for homestead exemption that they provide to the county. And as soon as they provide that to them, it's okay. Like we've never had a single issue with it. So it's really important to remember, if you're creating trust, make sure you have that homestead exemption clause in there and section in your trust, and make sure you inform your clients. These days we just tell our clients ahead of time, hey, once we move the home in the trust, you're gonna get a letter in the mail. It's pretty easy. All of our clients do it. And you just give them what they need, and they give that exemption to you. You can keep it. So I just wanted to spend a little bit of time on that because I know it's something that a lot of people have questions about. Okay, so the law that I mentioned earlier, that is a federal law that allows you to move your home into a trust. It's called the Garn-St. Germain Act. And you can look this up online, but it is the law that gives every American the constitutional right to decide how their home should be passed down when they're gone. And so if they choose to pass it down through a trust, put it in a trust, and then it passes down to their loved ones, they have every right to do that. And so a mortgage company and a lender is not allowed to call the loan. So the due on sale clause that everyone is worried about when they put their home in a trust, it is not triggered by moving your primary home into a trust. Now, if you have a rental property that you probably don't have 20% equity in, it's a second home or an investment property, that has its own requirements. And we can talk about that if you have a question on that. But as far as your primary home goes, you're allowed to move it. You can move your clients' homes into their trust, and it shouldn't be a problem. And the borrower remain the grantor of the trust, right? You don't have to tell the mortgage company, your clients don't have to tell the mortgage company that you have moved your home into the trust. Now, if you want to do it to be proactive, by all means, go ahead and do it. But in most cases, they don't even know. And a lot of them now know that it is a law that allows people to do it, so they don't bother even making a fuss about it. The last thing I will mention on this, which is really important, is letting the homeowner's insurance know that the house has been moved into the trust, because we've seen in California recently people did not do that. Their homes are owned by the trust, and insurance companies literally denied all the claim. Even with the fires, it was really scary and sad. And so it's really important now to make sure that the homeowners know that your trust is the owner and that your trust is added as an insured on the policy. Okay. And then one thing I want to also mention is that the transfer into the trust really doesn't make the grantor not the owner, right? The grantor of the trust, the person creating the trust, remains the owner of the property, not until they pass away, then it passes down to their loved ones. All right, let's see. Did you have anything to add to that for Wes before I move on?
Yeah, those are amazing points. Just on top of that, I always provide my clients with a memorandum regarding funding of the trust, where
Mhm.
it'll clearly say real property, checklists are the lender, of course, as Omi said, there's laws that protect for homestead, but maybe other properties. Even I'm not sure what do you think about this, but title insurance, when you get title insurance, I always tell them to reach out to the title company to make sure it's still covered. But definitely home insurance and just the homestead exemption to make sure whether you need to reapply. But yeah, that's generally what I do. Just make sure you give them a memorandum regarding all their assets on how to fund it.
Yeah, no, absolutely. In fact, we take it a step further. We actually move the home for every client. Like that is part of our trust plan. When a client creates a plan with us and we create a trust for them, their primary home is automatically moved into the trust by us. Because I have had people who come to me and they've had loved ones who created a trust in the past, and then unfortunately, the home didn't make it to the trust. The other assets didn't make it in the trust. So they basically bought a very expensive document that didn't work for them or their loved ones. So we make sure we move that. And then we obviously give them unlimited guidance to move the other assets. We kind of set meetings periodically to check in with moving all the different assets, because ultimately that is what determines whether the trust is going to work or not. Yeah, awesome. I think this one might be your slide, if I'm not mistaken.
Yeah.
Yeah, I'll let you take that one.
All right, thanks. Yeah, those are all amazing points. And I just want to talk about just kind of circle back. Um, regarding what the Quran mandates as far as your religious duty and testamentary freedom. So in Texas, you have full testamentary freedom, meaning you can give anyone your assets and any percentages, and you can say this person gets nothing or this person gets everything. It's all up to you. Where, the Quran, there's very specific limits, but if you want to think about it. This is again the client's choice. So that this is his freedom, his or her freedom to want to distribute it according to the Quran, and your job is just to help him do that in an Islamic compliant manner. And then I do want to talk a little bit about spousal rights. So Texas is a community property state, meaning, generally speaking, the default rule is anything you purchase or any income you have during the marriage is considered community property, meaning half yours, half your spouse. There's a few exceptions to that. One of them is anything the spouse owns before marriage is separate property. It's not community property. Property acquired by a gift during the marriage, even if one spouse gifts the other spouse something, that turns into their separate property during marriage. Property acquired before or during the marriage by device or descent, basically through inheritance, that's that person's separate property. Recovery for personal injuries, that's also separate property. So basically, you have to look at these rules and kind of determine is it separate, is it not? And these could be litigated in the future, even though you say this is my separate, it could not be. So if you have separate property from before the marriage, but you add it to the same account of your community property and it's commingled where you cannot trace it back, then it's commingled, it cannot be traced, so it loses its separate property status. What can you do about that? In general, there's a few tools you can use. You can do prenuptial agreements. You can do post-nuptial agreements or transmutation of property into separate property agreements. Basically, you can have agreements before or during the marriage of what property is characterized how, or this is what we're doing with our separate property, or anything after this date is separate property or community property, however you want. But you want to have some kind of clear agreement. If you want to have more control over who owns what, those are the tools to use. Otherwise, it goes to the default, Texas community property system where they just determine based on when you purchase a property or what you had before marriage or whatnot, what property is community and what property is separate. Um, this is kind of uh, I guess a gray area for me because Islamically they say, well, this is your property. Texas says it's half your spouse's. But the other thought is the Quran says whatever you own, distribute it in this manner. But Texas says this is what you own. So this is all you can own unless you do put one of these prenup, postnup, or transmutation agreements in place. So if you're not sure how you own your property or you want to have some agreement with the spouse, definitely present this to the client and say, hey, look, this is a community property state. If you want this property to be all your separate property or vice versa, we need to have some kind of agreement in place with the estate plan. And I mean, if you want to add to that, I know you do prenups, postnup, and transmutation of property agreements. So if you want to add a little bit to that.
Yeah, this is something that we had multiple conversations with clients, and you and I talked about this, but back to the estate planning piece of it, when there is no clarity as far as who owns what, then it becomes really hard to create an estate plan for Muslim clients because by under Islamic laws, you have to keep your assets separately because the husband's assets are distributed based on those requirements in Surah An-Nisa, the same as the wife's, assets. So if the way we do it, what I wanted to say is basically we try to keep the trust separate. That's the best practice is to do two separate trusts, one for the spouse, one for each spouses. And that makes it very clear because each trust is going to list out that person's assets. And so I understand that sometimes it's too expensive, right? As you can imagine, creating two trusts instead of one. So if clients decide that we want it joined, we just have to be very precise about whose assets are which, and also list them out in the joint trust. And that requires more frequent updates because as they acquire more assets, it's going to be more updates. And then lastly, creating a community property agreement that states we understand that Texas is a community property state. And even though that's the case, we have chosen to distribute our assets in accordance with, this law or however we lay it out in our trust, regardless of whether or not this is going to be in conflict with community property law. They have the right to do that. So once they sign that agreement, that makes things a lot easier later.
All right, thank you. And then the last point, disqualification of non-Muslim heirs based on the Islamic distribution. If you're non-Muslim, you're disqualified. Of course, you want to be careful and not write that directly in the will or document because U.S. law does prohibit religious discrimination and testamentary transfers. So, they can disinherit someone. They can say this person specifically is disinherited and gets no part of my estate. They can do that. So they want to make that decision up front whether they want to do that or not. And if later on they want to add them, they would just need to amend it. So that's all I had on this slide.
Let me go to the next one right here. There we go.
Thank you. Okay, so as Omi said, the will governs probate assets only. So there is a court process for assets for if you don't have a trust or whatnot, and you have a will, you go through the probate process. Now, there are some non-probate assets. If you own a house as joint tenants with rights of survivorship, that's a non-probate asset because if one spouse passes, the other is automatically the owner. That's not a probate asset, regardless of what the will or trust says. This is what happens. Payable on death. If you have a bank account, brokerage account, retirement account, life insurance, and this is the beneficiary at the time of death, that overrides the will. That person gets paid out directly. Whatever is in that account. Transfer on death deed is another tool for real property. It says when we pass away, you file it, and if you pass away, then this person or these persons are automatically the owner. That comes into effect at the time of death. So those are all good tools to use, but not when you're doing Islamic estate plan because of this reason. It's very specific how your estate plan is distributed Islamically. And if you have joint tenancy or payable on death on a certain account, then automatically that person or persons are getting a different share than everyone else. So if you add it all up, it's not going to be distributed all Islamically. So you want to make sure all your assets are all under one umbrella and all distributed according to the Islamic law if that's the client's wish. And really the best solution is the use of a revocable living trust, because with a revocable living trust, you can name these beneficiaries on your retirement accounts or life insurance as the trust itself. They pay out the trustee and it's distributed Islamically. It's all under that big umbrella. To me, that's really the best way to do it. Even rather than a will, because if you have a will and you have someone as a beneficiary designated, I designate my wife as a beneficiary of this account, she's getting more than she should. So those are just things to think about. And feel free to add to that, Omi, and that's all I had on this slide.
No, I agree with you 100%. Everything you said, I second. Yeah, I think this is mine. So let's talk about guardianship and healthcare planning, or the way I like to look at it as incapacity planning in general, and guardianship of your children, obviously. So, and one thing that a lot of people don't know actually is that when you're incapacitated, you can name guardians for your children as well. About 70% of Americans have not designated legal guardians for their children. And what happens when you don't designate a legal guardian for your child? You're leaving it up to a judge to do that for you. And the judge can appoint a non-Muslim, right, to raise your child. And so if this is something that, is important to your clients, you have to remind them the importance of designating legal guardian, not just in the will, because that's the common way of doing it. Designating guardian in the will, it becomes effective when a person passes away. If you're incapacitated, I've seen a lot of families that unfortunately, something happens to them and they don't have many family members around, especially immigrant community, right? Maybe you're not here with all of your family members. And so the kids end up in foster care or with CPS, and so you want to make sure you avoid that. And then advanced directives and medical powers of attorneys deal with specifically with your incapacity and your healthcare decisions. And so, as someone who is a resident of Texas, right, Texas law allows you to leave directives to physicians. So essentially, you can say, take me off life support. As soon as two independent physicians have certified that I'm in a coma, I'm not gonna come out of it, take me off of it. Now, there is, various opinions when it comes to that in Islamic law. And so again, as we're not scholars, it comes down to the client and what they want to do when it comes to life support specifically. Now, when it comes to euthanasia and assisted suicide, obviously that is strictly prohibited in Islam. And so some people consider being taken off of life support. And even if you're in a vegetative state, some scholars think that's still considered euthanasia. But that's the thing, right? Clients have to kind of figure out what they're comfortable with based on the school of thought that they follow, and then tell us what they think is best for them. And then it's up to us as professionals to see if that aligns with our values and if we want to go ahead and work with that client based on their choices. But currently in Texas, assisted suicide is not even allowed anyway, because that's a completely different thing than being taken off life support. And then um, the last thing there I think is, okay, yeah, very important if you want to leave specific wishes, and my clients do this all the time. I have clients that say, if I'm on life support, I want to be fed this specific type of food, right? I don't just want to be fed that Nestle stuff that they feed you at the hospital, like when you're on a feeding tube and stuff like that. So there are so many different ways you can make your wishes honored. You can make it to be in compliance with Islamic law of inheritance and Islamic Sharia law in general. Um, let's see. I think this one is mine too. So let's talk about burial and funeral and organ donation. And I believe Fawaz has already touched on this, so I'll make it quick because we're actually getting close to the end of time. But under Texas law, obviously you're allowed to leave instructions for disposition of remains. And there's a one-page document called the Texas instructions that we do for our clients. And you can essentially say you want to be buried, and this is the person in charge of it, and this is how you want it done. It's a one-page document, and funeral homes must follow that. They don't have a choice, right? So this is where you can have your wishes honored. Any wishes for ghusl, shrouding, janaza within 24 hours, all of those things can be respected if you have it written out in your instructions for disposition of remains. And I think that those are the main things. And feel free to add something there if you want for us. I think that we've already talked about that one a little bit earlier.
No, that's exactly right, and that is important to have that one pager, just nominating someone because at the end of the day, that's the funeral home. You can put those wishes, but the funeral home wants to make sure who's in charge and whoever you nominated, they're full discretion. And then there's our guidelines. So a little bit about these case studies you see here. There's three different types here. Number one, the community property issue, a Muslim client with community property state with non-Muslim spouse. And then the next one is blended family with Muslim and non-Muslim heirs and client with significant assets in joint tenancy and retirement accounts. You're going to come through those, clients are going to have these general issues. So Muslim client with community property state and a non-Muslim spouse. Again, you do want to take advantage of those agreements we spoke about regarding prenup, postnup, transmutation agreements, if that's what they want to do. But non-Muslim spouse, if they're disinherited, so they need to the other spouse, the Muslim spouse, needs to make a decision. Do I want to disinherit based on the Islamic law? You need to bring that to their attention. Blended family with Muslim and non-Muslim heirs, same issue. Say, Islamically, this is what it is. Would you like to do that, disinherit these people? However, you have that 1/3 optional bequest. They can maybe be provided from that, or during your life, you can give people whatever you want during your life. These Islamic laws are generally after you die, this is what you do. This comes into effect when people say, well, I want to make sure my daughter and my son get the same. And Islamically, they don't. You say, this is only at the time of death. If you want to have an Islamic plan, this is how it's going to be distributed. But during your life, if you want to gift them something or do something extra, I don't believe, there's nothing. And Omi, feel free to correct me, but there's nothing that prevents any gifts during life. This is really at the time of death. This is how it's distributed.
Yes, absolutely. This is just for when a person passes away. You can give a gift when you're still alive. I did read somewhere in some Islamic literature where you cannot do it within a certain period of time before you pass away. That's going to be considered sort of, your time is coming to an end, so you decided to do some sort of gift to avoid following Islamic laws of inheritance. Yeah.
Thank you. And then again, joint tenancy or retirement accounts, you want to let them know, hey, these are the beneficiaries. This is their money. They have no obligation to distribute it Islamically, even if that's what you tell them to do. So you might want to consider a revocable trust or different options because you just want to you really want to discuss with the client, here's your situation. This is what's going to happen unless we put these measures in place. Are you okay with that? Once you give them all those and just say, if you do want to do a Muslim plan, this is what it's gonna look like. Are you okay with that? And that's what's gonna happen to all your assets. And if they're okay with it and that's really their wish, then you did your job by explaining to them all the pitfalls, all the different options, and drafting it properly where all their assets are accounted for. And that's really all I had on this slide.
So, thank you, Fawaz. So I'll talk a little bit about ethical duties and risk management. We've already touched on competence, and just kind of communicating with your client about the importance of following the religious, guidelines and Islamic law of inheritance if you're talking to a Muslim client, right? Making sure that they understand, that this is what they should do, and then it's kind of up to them to decide, right? And then you also want to make sure for yourself that you actually are competent enough to structure these estate planning documents where if you tweak it to a point where you wanted to follow the Islamic laws, that you're not making that document, you know, kind of illegal in a way, honestly, or in a way that it's not going to be able to work for your client, right? So make sure that when you do that tweaking and you make those changes, that they will actually comply with Texas law as well as the Islamic laws as well. And then avoiding conflict, especially, if you have some type of feeling towards giving assets to non-Muslims and stuff like that. If you feel like that's something that just doesn't align with you, or from a religious context, maybe certain people are members of a family and you just feel like it doesn't feel right. I have turned down clients many times, right? I have served hundreds of clients, but I have also turned down many clients because it just didn't align with my values. It didn't fit. Um, and then from the risk management standpoint, um really I don't know if y'all have heard of CYA. You send a letter to a client just basically telling them that I have told you to do this, but you have refused to listen to me, in a nice way, obviously. And of course, just letting them know that you have done your best to explain to them what you had advised them to do, but they have chosen to do something different. Because if you feel like you want to take on this client because of some sort of value or other reason why you think you still want to take a client that isn't listening to you, you can send that CYA letter, and that will help hopefully cover the risk, right? And if you want to go a step further for a client, you can work with a scholar where it makes sense and maybe ask the questions on behalf of your client and kind of figure out what is the best way to move forward. And then for the last slide here, we have just a quick drafting checklist that you can use to kind of integrate Texas Islamic estate plan. The main documents that are really important, and this is not necessarily a document, but in our office, it is a document, a comprehensive asset inventory that identifies all of the probate and non-probate assets. This is standard for all of our clients because at the end of the day, we realize that even not with not non-Muslim clients, a lot of people create a estate plan and their loved ones don't even know where to find those assets when they're gone. So that comprehensive asset inventory is a standard. And then obviously you want to verify the testamentary capacity, and then you draft clear revocation clause in there, include executor and guardian nomination in the will. And personally, there's a program I specialized in called Kids Protection Planning that allows you to nominate guardians for your clients, basically even when they're incapacitated, not just when they pass away. And then obviously we talked about burial instruction, the one-page document. And then the Islamic wasiya and fixed share plan, really important to include that in every will or trust. And then you can coordinate title when it comes to titling the assets and beneficiary designation. As I said, we have periodic phone calls for our clients to make sure that they have done all of these things, because we don't want them wasting their money creating the trust and not properly titling the assets. and then HIPAA release and powers of attorneys so that their wishes during incapacity is going to be honored as well, that we've talked about with, euthanasia and so on. And then documents that also reflect the client's religious intent in the engagement letter or a memo. Like I said, CYA letters. You can send out CYA letters after you've explained the requirements for religious provisions to be included in there. Or in the engagement letter, you can make a statement in there that says we're creating this under the Islamic laws of inheritance. I don't think that one you have to do it, but I think the CYA letters are actually my favorite thing when you have some sort of conflict with a client like that. Anything else, Fawaz, you want to add to that?
No, I think that's everything. You covered everything as I would, so I have nothing else to add.
Wonderful.
You guys are amazing. Wow, mashallah. Thank you so very much for running through all of that. There were so many nuggets that I took down while you guys were talking, and we've got a couple of Q&As as well. So let me get to answering those and getting those in front of you. If there are several of you in our attendees panel section, feel free to drop in a question that you might have. The first question that pops up here is about the schedule you would attach to a will, which would be the Islamic law schedule. And the question was, are Texas judges willing to interpret and rejigger based on the schedule, in your experience, or how have they dealt with that situation? Because there's some hesitancy to attaching a full, complicated Marwat schedule.
Yeah, I mean, I agree. I probated a will with a Islamic schedule. So in probate, generally, they don't, not that they don't care, but they say, they take your word. Hey, here's the executor. The executor said these are the beneficiaries. They take the executor's word throughout, unless there's litigation, there's a dispute. Hey, according to the schedule, I'm entitled to this. Now the problem might come in when they interpret the schedule and say, we cannot determine it. This is what we're gonna do. That's why I believe, you could, and that's what I've been doing, is writing it out specifically. This person gets this, where on its face it doesn't even look Islamic. I don't even have those words in there. It's just a bunch of percentages, and it'll say in the event they predecease someone, this is added here, so it's a formula. And if big life events happen, we tell them to go ahead and update it. But I feel like that's the best. If it goes to a judge, they know exactly how it's distributed. But I mean, I'll let you carry on with that.
Oh, Fawaz, you know what I'm going to say? That's why I advise my clients to do a trust versus a will, because you then avoid all of that. A judge doesn't need to read your trust and see that you're doing it based on Islamic laws of inheritance, and then you get the bias that comes with that. I had a judge that ruled against me because I was an immigrant. He said it on the bench. He said, y'all can go back to your country. I don't care. It was during my divorce. So I've seen where judges can be so biased to a point where I simply tell my clients, if you can do a trust, it's just better.
Completely makes sense. In that same spirit, we've seen wills talk about the Marwat schedule and looking to the schedule, but if there's a conflict, it then brings in the imam, right? You can designate an imam at a mosque to help the judge. Have you seen that work out well?
I personally haven't seen it, probably because yeah. What about you, Fawaz?
I haven't seen it, and I don't want to get to that point, so I try not to add all that. I try to make it as clean as possible, but yeah, if you put that in there, like, hey, if there's a dispute, we're gonna have a local Muslim imam at the discretion of the executor. You can put that language in there, but you want to make it as easy as possible for them. But can you put it in there? Yes. Is it the easiest? Maybe no.
Perfect. And a couple of quick fire questions here that popped up that I wrote down. You talked about the homestead exemption and that kind of transferring over with the trust. Is that the same for the 65 and senior exemption? Does that transfer over, or do you lose that exemption with the trust?
It all transfers. That includes the VA exemption. Some people don't pay anything in taxes through the VA exemptions. It all applies. Yep.
Perfect. The other question was on it might not be able to touch on this topic, but the difference between a revocable trust and a Medicaid trust, right? A trust you would set up to kind of help you with the Medicaid program. Is that, can that be incorporated in, or is that a different beast in its entirety here?
Oh, it's a whole different beast. I'll let Fawaz take it, but I'm like, once you mentioned it, I was like, no, that's a whole different beast.
You're talking about the special needs trust, is that right, me? Or
Medicaid Asset Protection Trust.
that's a separate one, yeah. That's a whole nother deal. Um, but yeah.
So is there a lot of symbiosis between the two, or you really can't marry the concepts together because it's different in its very nature?
Oh man, I don't think you can mirror it. No, it's a whole different thing on its own because you're trying to get rid of the assets and just don't have them be the grantor's assets anymore.
Yeah,
Right.
so there is a for SSI or Medicaid to not lose those a correct me if I'm wrong, I mean there's special needs trust, you can
Yeah,
create that
supplement.
separately,
Yeah.
or you can make it created saying this beneficiary, anything they get goes into this trust and create kind of like a contingent trust. And that would help them, that would give them more money or more accessible means where it doesn't trigger Medicaid or anything else, where they keep getting their benefits. So there are different things. Definitely have them, definitely see if those are options to incorporate in there because there are some things you can incorporate in there in that regards.
Absolutely. So for special needs, is very different from Medicaid asset protection. You can definitely do that with special needs and supplemental needs trust, 100%. I see Sarah said, Umi, we have a
Yep.
peace of mind book. What is that?
Yeah, that's interesting. There's got to be some peace of mind book. I guess she has one for their own assets, and they recommend you guys looking into that. Okay, so you're gonna have to ping us and tell us what, give us some more information. Two other quick ones, and again, if folks need to go, absolutely understand. I've got the CLE number on the screen for folks to write down. One attendee said, "Have you had any experience with trust in the context of divorce? Once a spouse puts assets in a trust, does that remove it from the community estate?" Okay, so there are two questions, I suppose, in this
Yeah.
one.
So the question is, once you put it in the trust and you get divorced, are you able to remove it? Yes, you are. It's a revocable trust. That's a simple answer to that. Yeah. What was the second part?
I think you covered it in both there. Yeah. Yeah. I guess the question might be, the follow-up there would be, if the assets are a community asset, then how can one spouse revoke that trust, or do both need to be involved?
If the trust is made by both, then both need to revoke it.
Got it. And that'll probably just happen in the context of the divorce proceedings.
Yeah,
Yeah.
exactly.
Next one is Islamically for trust. Can you give a specific age for kids to access assets when the parents pass away at a young age? So this is probably them asking, what have you often seen when a kid is 5 or 7 and a parent passes away? What is a common age to actually pass the assets as beneficiaries?
Do you want me to take that for us, or do you want to take it?
You can take it, that's fine.
Okay. Yeah. So this is something that I see again and again with clients where they have young kids. So when you create that trust, there is what we call lifetime asset protection trust. So the distribution is going to stay the same in accordance with Islamic law. Nothing is going to change, but the assets pass down to the kids in that trust instead of in their name. So you're just appointing someone to oversee the management of the trust when you're gone. And so the kids are going to be receiving money for their care. There's the HEMS, we call them health, education, maintenance, and support. So they're going to be receiving money for those things. And then when they reach a certain age, and you can get to tell us as the professionals doing it, hey, if they reach 25, they can have control of it, or 30. Or you can say, well, 25, they can start having some control, and then at 30, they can have full control. There's so many different ways you can do it, and that's the beauty of the trust.
And Islamically, are you aware of any age per se that,
I actually
scholars have
am
agreed
not.
upon?
No, actually, I'm not aware Islamically. That's a good point to look into.
Yeah.
So for
Um,
me, I and I don't know Islamically scholars and stuff. I feel like if they're 18 or 18, they should get those assets because at that point, this is their right, and you're still withholding it. So there's no need to when they're adults. They can buy property, they can own property, they can do everything they can as an adult. So that's why I say, just do it at 18. No need to do it. Some people want to do it till they're 40 or whatnot. I'm like, those are their
Oh my
assets.
gosh,
You have to give it
40.
to them at some point.
There is an argument to be made that people who receive a huge amount of inheritance at 18, they do not know how to support themselves. They cannot handle anything financially, or they can't graduate from school and stuff like that.
Yeah.
Yeah, those are very good points. And it's an awesome tussle that you see that each one of our clients would have to wrestle with to kind of come and get mashwara and guidance from scholars and opinions and consult on these important items. The last one we'll leave with is just yeah, we'll have your contact information here and we can share that, of course. Do you all usually have a range as far as an estimate on uh, the cost of the trust or a putting together a will, just generically speaking, in the safety net of our community to figure out, when they're talking to potential clients and referring them to you, when they ask the inevitable question, am I looking at 10,000? Am I looking less than 10? Am I looking more than 5? Do you all have a range that you go out with?
Yeah, I have a range for us. Do you want to go first, or do you want me to go?
Yeah, I mean, I have a range, and I know that there's different attorneys, they have different ranges, and it depends on the estate plan if it's straightforward. So I tend to stay on the lower end just to kind of, I guess, because I kind of do it as more, kind of as a community service deal. But the estate plan, if you want to do a will, it should of course, going to be, I believe, under 1,000 even for married couples in a trust. What would you say the average is in the market rate? I imagine it's like 2 to 3,000, something like that.
Oh, the market rate from people that come to me is actually more 5,000.
Okay.
Yeah.
Yeah, so it does vary and it depends on your situation and the assets you want to transfer. So that could really lead up to a lot of hours.
Yeah.
I would just say it's, based on client to client.
Yes.
Yeah.
That's what
Very
I was
good.
gonna say. Yeah. Go ahead, Fawaz. Yeah.
No, it is client to client can vary greatly, and until you know their assets, what they're trying to accomplish, it's hard to give them, a flat fee or whatnot for it.
Yeah, absolutely. And the same thing goes for me. I always tell clients until you sit down with me and go through my 2-hour legacy planning session, there is no way for me to tell you how much it's going to cost. I mean, I can easily tell you that if I'm just giving you a one-off DIY document, I can give that to you for free. But if you're looking for a counselor that you're going to build a relationship with for the rest of your life, you're going to be sure that your plan is going to be updated. Every 3 years, we do free reviews and so on. I explained to you how our system is set up to support you. Then you understand the value of what we're bringing to you as counselors. Then they know that the reason why our packages start at $3,000, right?
Yeah,
And that is just not just it's not just a will. It's like a series of probably 25 documents covering all the bases, plus the free reviews, plus asset inventories, plus fiduciary letters. I can go on and on. So it's just a matter of understanding what's important to the client. And if just one will is what they need, I can give it to them for free. That's just me. Yeah.
yeah. And to Ami's point, they need guidance, they need hand holding, and it's not just a one-time thing. They need a relationship, and regardless of the cost, going through probate for the husband and going through probate of the wife is going to be way more than that automatically and more inconvenient.
Absolutely.
Yeah, 100%. And again, thank you so much for you guys for walking through the nuts and bolts of not just what wills and trusts work like in Texas, but the overlay of the Islamic aspect, but then also the struggles and the points of school of thoughts kind of coming in and really being underlining the importance of sharing the counselor role that you guys have, which I know our clients never appreciate, but when they hear it, it starts to click and manifest itself like, okay, this is really what I'm getting. It's not the document and the pages, but the analysis and the thought behind it. And I'm sure a lot of them appreciate the fact that you're able to pull that together with them in a great fashion. A lot of people are saying thank you. So again, thank you from the DFW Muslim Bar Association. Thank you for sharing your expertise. And inshallah, we will honor you guys at the next event that we have. But thank you again for taking the time. We'll share your contact information. There are a few people that wanted the PowerPoint. Feel free to email me and I can talk to the panelists about that. And otherwise than that, thank you everyone for such a great session.
All right, thank you, Fawaz. Thank you, Umi.
Thank you so much,
Appreciate it.
Fawaz, for putting it
Walaikum
together. Thank you. Assalamu alaikum.
Alaikum salam.